My Lords, this amendment is a reproduction of the amendment on secondary action which I moved in committee. Your Lordships, of course, are far too polite to give expression to the collective groan which would otherwise emanate from all sides of the House. But I do move the amendment again for two particular reasons. One, because the issue raises important factors of which I'll remind your Lordships briefly in a moment, and secondly, because support for it from various unions and the resistance to it by the government in committee, and I surmise today on report, gives the lie to the repeated allegation that this government is a puppet manipulated by the trade unions. Lords, this amendment contains 6 measures aimed at restoring statutory protection for solidarity action which subsisted between 1906 and 1984. As before, I'm grateful for the support of ASLEF, Bakers Food and Allied Workers Union, BMA, Fire Brigades Union, RMT, University College Union and Unite. Your Lordships will be pleased, of course, to hear that I won't rehearse the arguments that I made in committee, save to remind the House of 2. Firstly, solidarity action is an inherent aspect of freedom of association, which is the jurisprudential and international underpinning of trade union freedom. And, at a more mundane level, the very essence of trade unionism. Solidarity between workers is not confined to the happenstance of employer identity, especially in the light of the fragmentation of enterprises in recent years. Secondly, my Lords, the issue is one of the rule of law. Lord Bingham's 8th principle requires compliance with international treaty obligations ratified by each state. Those obligations are elaborated by the supervisory bodies established by the relevant treaty to which the state adheres. Their decisions are as much part of international law as the treaty which authorised them. The right to strike is guaranteed by ILO Convention 87 and by the European Social Charter of 1961, Article 6.4. The decisions of the supervisory bodies of each hold that a prohibition on secondary action by a ratifying state violates these respective provisions. The United Kingdom, of course, has ratified both ILO Convention 87 and specifically Article 6.4 of the European Social Charter 1961. And the UK is also represented on both the ILO supervisory committees, the Committee of Experts and the Committee on Freedom of Association, and from time to time it has appointed a representative to the European Committee on Social Rights. Lords, the Labour Party's Green Paper, called a New Deal for Working People, endorsed by the Labour Party conference in 2021 and 2022, committed the party to a regulation of industrial action law which complied with international law. The situation is that the supervisory bodies of the ILO since 1989 and of the European Social Charter since 1991 have repeatedly found that the UK ban on secondary action is in breach of the respective treaties I've mentioned. The ILO most recently proclaimed this in 2024 in the Committee of Freedom of Association's report on the P&O ferries scandal. The European Social Charter most recently repeated the same conclusion in its cyclical report on the United Kingdom in 2023. Lords, in my respectful view, this situation of international law breaking by the United Kingdom is simply not tolerable for a country which purports to uphold the rule of law, and therefore I beg to move.